Hi everyone, I'm Matt Vincent, if we haven't met, and welcome to this afternoon's panel session. I will quickly introduce our panel members, but don't want to cut too much into question time, and really the objective here is to make this interactive and give you an opportunity to interact with the panel. So, starting at the end, you obviously know comedian and entertainer Professor Sparrow, needs no introduction. Next to Professor Sparrow, we've got Catherine Meyer, who's the CEO of the Victorian Commission for Gambling and Liquor Regulation. I think, Catherine, you're a teacher originally, is that right? Also spent time in Telstra, has held senior positions in justice before taking up the role at the Commission. We've got, most people will recognise Stan Crepan, who's the CEO of Sustainability Victoria. Now, you might say Sustainability Victoria, that doesn't sound overly regulatory, but I can assure you that Stan has played a very, very strong role in shaping regulation in the state of Victoria through WorkSafe, EPA, more recently in relation to setting up and establishing Victoria's response to cladding. And Stan and I have worked together quite a lot over the years. Does anyone know the person next to Stan? Obviously Sue Eddy, for those of you who haven't met. Sue is a chartered accountant by trade, but we won't hold that against her. Worked in DTF in very senior roles, including running the state budgets process, Deputy Secretary at Digita in relation to corporate, so has had a lot of experience prior to taking up the role here. And then hopefully most of you would have seen this morning Dr Owen Donald, who's our Chief Commissioner of the VBA. Owen, your career is just too extensive to even read out, other than to say Owen's had numerous roles across both, I guess, the social sector, but also the commercial sector in things like Melbourne Ports Corporation, Aboriginal housing. So he's been a board member, but also a CEO of a regulatory authority previously. So very senior positions. Thank you all for participating. So I'm going to warm them up, but I'm literally warming them up for you. So I'll kick it off, and then I'm going to throw to the floor. Catherine, I might start with you. You grabbed the mic earlier today, and you were talking about your organisation starting to rethink and morph in terms of its regulatory approach. And I'm interested in you talking a little bit about what are some of those influences in the Victorian context that have taken you down a path of needing to rethink?
Well, the VCGLR was set up in 2012, so it brought together the gambling side of regulation and the liquor side of regulation. And, Malcolm spoke about mergers and how challenging they can be. Within the first 12 months, we'd had an Auditor General's report on the liquor side of the business that we needed to respond to. So that was in 2012. In 2015, the government brought in a new chair of the organisation and asked him to conduct a review. That review led to some recommendations for government, but it also led to 31 internal actions that I was expected to lead. And then we've had a subsequent Auditor General's report into the organisation, and so we've got quite a few critical friends looking at us and telling us about what we're not doing right, and somewhere weaved into some of those reports are things that they've said that we are doing well and that we're on the right track. So it certainly has provided the impetus for us to really reflect on who we are, the type of regulator we want to be, and what is going to be our way of regulating the gambling and liquor industries. And so the establishment of development of a regulatory approach statement was really the catalyst for us to engage with the broader organisation about what being a regulator means for our organisation, and really starting to use some of the language about our regulatory craft and being regulatory practitioners. And there was a real effort to engage with staff and take them on that journey and establish that common language so that we could, really be rallying everyone into the same direction and to, achieve the same outcomes.
Thanks. And Stan, you've been not only the recipient of critical friend advice, but you have been the critical friend in a couple of occasions. Do regulators need these regular reminders that they're going off track?
Unfortunately, Matt, I think they do. And I've actually been on the receiving end of those reports, and a bit like Catherine was saying, the Auditor-General, the Ombudsman, we've got a long history in Victoria in particular of external to agencies but internal to government reports and reviews who actually understand regulation, and I think that's been part of our reform, is that we've got people that are looking at our work and that we're subject to that sort of scrutiny. And I guess my view as both a head of an agency and also having been a practitioner in the regulatory space is that you actually need that impetus, you need that reminder. We were just talking before, because it gives you a kind of social licence, if you like, or social pressure to do your job. And our job is tough. The job of regulators is always tough. You're necessarily either threatening people's livelihood or you're scrutinising their business or their industry, and that's not comfortable for anybody. And in those tough times when you're making tough decisions to prosecute, to issue fines, to shut down businesses, as I have over in the past, in WorkSafe in particular, you actually need that social pressure and that licence that says we respect your work, we respect your craft, and that sometimes you've got to make decisions that are tough. My perspective is probably coloured a bit by the 20 years that I've been in this game, that I've been involved in either the recovery or in the thick of what are essentially regulatory failures, and we've had royal commissions, as you know, in Victoria into WorkSafe and others, and so I necessarily take that with me because I've seen those failures and how they've happened, and often the root of it has been that lack of support or mandate to go hard when you need to, and nobody forgives you when you don't and something goes wrong. And so ultimately I think in those situations, which are generally low frequency, high consequence events, when they go wrong, the first person that they look for is the regulator. Who was in charge? Who was responsible for preventing this? And if you're found to be wanting in that area, then you can expect people to come after you hard.
Yep. So on that note, Owen, Sue, whilst we haven't got critical friend breathing down our neck right now, we've recently had the Hayne Royal Commission into the banking sector, which is another sector that we could perhaps look to in terms of lessons learned. What's the takeaway from something like the Hayne Royal Commission happening around us?
Well, I'd just name a couple. Firstly, I think that the Hayne Royal Commission put its finger on an issue that Malcolm drew attention to, and that is that, in fact, the Commonwealth regulators had not been dealing sufficiently with the customer side of the ledger. So they were on prudential regulation, they were going gangbusters. But on the protection of consumers and the public, they had been weak. And of course, we have our own big parallels here, including in the building sector. So we have been and we wish to remain very close to our industry partners, and I'll refrain from calling them customers because I don't think they are, but I do think that they are partners with us, and we do co-regulate, whether we want to call it that or not. What we have had to do as a consequence of the cladding task force work, and of course the catastrophes that preceded it, and now in relation to NEO 200, which was just a kind of reminder, and of course the Opal Tower in Sydney, is that we have to put the protection of the consumers and the public in give it much greater priority than we've done. And it's just a reminder. It's not like that was never the task. It's just that it wasn't flavour of the month, the pendulum was way out to, well, not, was certainly swung some distance to the right, and we're now coming back to a more balanced approach that's got consumers and the public absolutely in the headlights, and that's exactly as it should be.
Matt, I'd probably say the catastrophic impact of when you have to sit there and explain yourself and the decisions you've made that really just don't make sense, they don't resonate with the community at that time. So it's the can we, should we argument that I think you lay all that out and it looks like, no, you shouldn't have, maybe you could have, but you shouldn't have. And so, you know, what drives an organisation through its journey to not be able to step back and reflect of those things that if someone else was to inquire later on, it just doesn't feel right. And I think you see the trust, you see the pain and suffering that individuals go through, you see what the organisations are going to have to do to rebuild that confidence, not alone the economic and social impact of what they've done. So I think for me it's, you know, not getting caught up in your own view of the world and your own decision making that might feel quite right in isolation. Maybe it's at a team level or a group level or a whole organisation, which is just not right when you step back. And I think we've seen a parallel in many cases in the building industry, and I think this point about safety, you know, you hear so many people can explain why they've interpreted the rules the way they have. Someone can point to a specific provision in the code, but when a layperson looks at that building, it just doesn't feel right. I think that's one of the things we really need to pay attention to, because, you know, poor decision making, all good intention has really catastrophic impacts.
Thanks. So that's at the local context. Most of you won't know that Professor Sparrow, some years ago now, I think was asked by the government to comment on aviation regulation. When was that, Malcolm?
The US government, yes, in 2008, a review of the FAA.
Yeah, so Professor Sparrow's had a lot of experience in the space. Just interested in your reflections on the Ethiopian Boeing 737 MAX 8 crash, and you know, what are some of the lessons in that as that unfolds and information's coming to light?
Well, we still don't know. We still don't know whether the FAA's decision to be the last in the world to ground the MAX 8s, 7 through 10, was in any way corruptly influenced. I think we'll learn about that. There are very clear associations between Boeing, the company, and the Trump administration. It was curious that it was Trump that announced the grounding in the end, and maybe that was a deliberate antidote to some of these nasty aspersions that were beginning to arise. We don't know whether the FAA genuinely failed in some way in its upfront inspection of this model. So while all of that is unknown, one thing we do know, we live in a world of buggy code. I don't know how many of you are coders and have ever written complex, long algorithms. I still do it as a hobby because it's kind of fun. Pattern recognition always has been for me, but the ones I write at the moment are fraud detection algorithms, mostly to operate on vast databases of healthcare claims data. And I know from experience, however careful you are, you're going to write buggy code. Now, we live in a world of buggy code, and Microsoft has to issue its updates all of the time. And now we're putting code in charge of issues of life and death. And I don't think we've begun to understand yet exactly how can you ever regulate the safety of code on issues of life and death. And once we have autonomous vehicles and school buses and heaven forbid, totally autonomous planes, we're in a whole new era of vulnerability, not just to buggy code, but to modes of terrorist attack through cyber intrusion. And I have no idea whether we're really paying enough serious attention to those yet. That's a major regulatory challenge.
Thank you. Are we able to get Slido up on the screen? Great. I'm going to ask the first of your questions on your behalf, and then I'll actually flip to the audience, but we can work our way through these. And I was really impressed to see that first one there around customer. And Professor Sparrow will tell you that I initiated this debate in Harvard actually while I was over there around, you know, what is the view of using the term customer? You know, is it dangerous to call them that? What is the right protocol? What is the right terminology to use for a regulated entity? And I'm just going to open this one up. I know, Stan, this is something you've looked at through the course of some of your previous reports. Do you want to perhaps kick us off?
I've probably got some more nuanced views than I had 8 or 10 years ago when I was at the EPA. The EPA had a practice, and we explored this a lot, and I think very much influenced by Professor Sparrow's work around using the word client for regulated entities. And I kind of understand completely as the head of an agency what that was supposed to connote, which is essentially that you're open to scrutiny, that you say that you do what you say you'll do, and that you'll do it within a relatively appropriate time frame. I thought that the EPA at that stage, that the word client had been used in a way that essentially meant that it was too close to the people it was regulating, and that it wasn't tough enough, and that the pendulum, to use Owen's word, had swung too far to them not being a regulator, and that what they were looking at was adding services as if those services were non-regulatory services. And indeed some of them were, and some of them competed with the work that I now do at SV on the other side: incentives, rebates, grants, a whole range of things in companies that they were regulating, which I felt were a complete conflict of interest. And so I think the word client or customer as in a regulated entity, I think is fraught. However, where I agree with Owen on his description of customers as the beneficiaries of the regulatory work, I agree entirely that that kind of framing of customers, if you like, of, and in this case in building regulation, would be the end users of those buildings. I don't mind whether you call them customers or residents or householders or whatever, but that community deserves to be better protected, I think. And so that's kind of my 2 cents.
Other views from the panel?
So it's probably a word you've heard me say a lot. Actually, we've got a couple of sessions next week or the week after to have this fantastic debate. So I love the diversity of the perspective. I think it's multi-dimensional for me. And I think maybe, you know, there's a language nuance probably publicly as opposed to how you treat the people that you work. So yes, we do regulate practitioners, but you would have heard me say we also have a service role. We have a role to efficiently register and licence them. So for me, the kind of customer focus, I mean, you've heard me say you are my customers. It's about a mindset, about a responsibility, about how we interact, how we see value from both sides. And I think when you're a regulator, it's being careful that you're not just there with that tool, that you are kind of respecting some of those fundamentals that need to be within that relationship. So a bit more nuanced for me. Is it a language that we should use just internally? Is it, you know, are you still a customer when we're at the hard end and forcing you and potentially taking away your livelihood? Well, again, for me, it's about an empathy about the way we go about what we do without compromising what we do. So, you know, do we hold people to account? Yes, we absolutely hold people to account. How we behave in holding people to account, I suppose for me, just as part of that journey of a sort of a customer service relationship. But where we are right now in the building industry with such low level of confidence in the system as a whole, I think I've definitely stood up and listened to Professor Sparrow and go, okay, do we have to be careful about how we use this word? Do we use it at all? But if we don't use it, how do we get that empathy? How do we make sure that our values and how we go about how we do our work and hold people to account, we don't lose sight of that? So I think the time is right to have that debate.
On this subject, I think there's an issue with words, I think there's an issue with methods that are relevant, and I think there's an issue of potential damage. If you wanted the most accurate word in this setting, I would say it's an ugly word, it's obligatees. You're in the retail delivery of obligations to people for the public good, and client and other more stakeholder, other more neutral terms don't bring the same dangers quite as the notion of customer, because that makes them feel entitled to be pleased with your actions, which clearly in some settings they're not. But the issue of methods is important. So you're setting up a registration system, and it needs to be accessible. There is a whole science and art learned in the private sector about high-quality customer service delivery techniques. That includes, client-facing web portals so that they only have to write their name and address once in order to get 7 different licenses. All of that is absolutely relevant. So even though it's got the wrong label, the methods still count. So as you set up registration processes, complying with them should be easy, should be convenient, should be cheap. Your use of automation and so on, websites and so on, all of that should be oriented to make compliance easy, cheap, and convenient. That is often called customer service or business engineering methods. They're all relevant. And then the potential damage, I'll just tell you the FAA story, because the reason that we had a blue ribbon panel to review the FAA was that a lurch way too far over to the right-hand side, the danger of regulatory capture, and a whistleblower had emerged from one region of the FAA. That's the region that deals with Southwest Airlines. That's the way they're structured. A region deals with one airline, and they call them the customer. So when he found that they'd contravened an airworthiness directive and flown 1,100 flights illegally, he said, we must ground them. And his bosses said, no, we don't do that. They are our customer. And he went up the chain, and every level he said, no, we don't do that. They are our customer. We have to work with them. We'll do something else, but not ground them, because that would ruin their business. And when he couldn't get satisfaction within the FAA, he went to the Inspector General's office, then he went to the New York Times, then he went to the senators and the congressmen, and there followed a very ugly set of congressional hearings. 2 days, called the Oberstar hearings, chaired by Representative Oberstar, and the whole senior executive team of the FAA was up there being grilled in one of these ugly public settings. How on earth could you ever lose your way? How on earth could you ever think that the industry was your customer rather than the traveling public? And one of the strangest things about the Oberstar Committee was that they considered seriously banning the use of the word customer within the FAA as applied to airlines, because they thought it had done so much damage. But then somebody reminded them of the American Constitution, which says you cannot regulate speech anywhere except hate speech. And this wasn't hate speech, this was love speech. This was inappropriate love speech between the regulator and the regulated, so they couldn't ban it, and they dropped the idea. But just the idea that this would occur to them showed how much damage it could do if it means you're incapable of taking firm action when it's actually warranted.
Live free or die. Have we got anyone brave enough in the audience to... I mean, we've got questions up there we can go through.
Always we can rely on David.
Can someone run a mic?
If we take the public as a club, then everyone within... Sorry about that. If the public, as we know, is a major stakeholder, and if we treat the public as a club, and that each person in the public is a member of that club, and therefore we need to act in the best interests of that club and every club member, that's a possibility. It's like you would say if someone is applying for a registration, they would be a candidate. If someone is a practitioner, then that's self-explanatory, and that perhaps there's an opportunity to use that sort of wording. It may not do the job, but it seems to be an alternative.
Sure. Probably more of a statement than a question, but Catherine, did you want to add anything?
I'm sorry, I thought I was still talking on the same
No,
subject.
all good. All good.
In our organisation, we have a client services team. It's the team that responds to calls, emails and mans the front counter, but we tend not to use that language in other areas of the organisation, so we refer to our licensees or regulated entities. But the language around a service-centric culture is something that we are focused on, and often we talk about the principles of what that might look like. So if we are designing a new process, how do we make it to be accessible, the most efficient way, that it meets both the regulators' requirements but also the requirements of industry as well. And part of that process is often working with industry to ensure that the new services that we're designing or the new applications we're designing meet both of those needs.
Can I just reflect on the term customer for a minute? It's not altogether surprising that we have seen practitioners as customers, firstly in relation to the registration and licensing arrangements, but secondly, you'd think of customers as people who pay for a service. Well, certainly, building industry pays for a service. It's a user-pays system. It does flow through in large part to, depending on economic circumstances, to customers, to the end customers, but up front, there's an impact on the industry. So we have to think about how that impacts on our relationship. I'm not saying for a second that that's wrong, but it does actually come with an obligation for respect. And that takes us to another aspect of the way in which we regulate. And that is that, as we've been talking today, if we're looking at, say, Model 1 on Malcolm's classification of models, Model 1, Model 2, even Model 3, to a very significant extent, relies on us having the knowledge to be able to assess objectives, to undertake the analysis and to manage the risk. The truth of the matter is that we are not the custodians of all knowledge in relation to building and plumbing, far from it. We have to work respectfully with industry, and to that extent, we are co-regulators, and we have it's a customer to customer or client to whatever kind of relationship you want to describe it as, it needs to be collaborative. And if we stop doing that, we will fail. So customers not calling our practitioners customers is an appropriate thing to do, but at the same time, we absolutely have to maintain that relationship of trust, because otherwise we will fail on both the dimensions of knowledge and our capacity to regulate through a relationship of mutual respect.
Thank you. Any others out there? Yep, got one over here and then Sam will come down.
Can't hear you.
Customers in relation to registration, and customers in relation to certain parts of the PDA, and then in other parts of the PDA, they're treated differently depending on what's happening. So I think it would be a mistake to completely remove the word out of our vocabulary. I'd rather use it contextually.
And as Sue says, there'll be a few sessions over the next couple of weeks where we can explore that. Do we want to jump over to the back? Yep.
Just following on with the technology issue with disruptive technologies, we're going through a phase where machine learning and automation is on the rise, and on the horizon we do have the impacts of deep learning, wherein the software engineers developing these programs don't actually know how they come to decisions and the decision-making process involved in it. Is it even possible to regulate a system like that in the future?
I think that's a fascinating question for us to ponder, and I think you need to be thinking about those issues now, and clearly they're top of mind for you. I think in the UK, the recognising, perhaps not so much around the technology, but the complexity of modern building, particularly high-rise building, is that Dame Judith Hackett, who did their review post-Grenfell into their regulatory environment, if you like, around building and safety regulation, has recommended a safety case regime, which is more suited towards managing complex systems and then regulating against that system rather than individual hazards. And I've got some time for that. I don't know whether that should be considered in Victoria, but that kind of meta level of looking at a system and how it's operating, how you audit against that system to make sure that it's in place to protect the end consumers is something that's definitely worth considering. The thing that always struck me from day one when we were doing the cladding task force is that in Victoria, at least, and most jurisdictions in Australia, there's a positive obligation on builders and designers of buildings to design them so that they're safe for people who are going to use the building as a workplace. That doesn't exist, as far as I can tell, for people who are going to live in a building, and that seems to me a gap. Because as much as we say that the Building Act is supposed to create a positive obligation and that we see it as primarily a safety piece of legislation, I reckon that somewhere along the line those things have become a bit decoupled. And people talk about the code but have forgotten about some of those fundamental underpinnings, that it's actually a code that's there to protect the people who are in the building.
Great. Any other? Sam, I think.
One for Catherine. So the VCGLR published its regulatory approach in around 2014. So I'm just interested to understand the process.
For Catherine, the VCGLR published its regulatory approach in 2014, and from my perspective it's clear, plain English, simple and easy to understand. I'd like to see if you could tell us what the process was for developing it. We're now 5 years on. Has it changed over time? And how is it influencing decisions on a day-to-day basis?
Okay. So there's a few questions in there. If I start with the beginning, we established a project team with people from across the organisation. So we had representatives from our policy and legal area, but we also had operational staff from licensing and compliance form part of that project team. There was a great deal of desktop analysis done, discussion papers written. We ran lunchtime sessions with staff. We went and consulted with academics, other regulators. We kept bringing that back into the organisation. We tested it with our commission, whether we were developing the regulatory approach in a way that they wanted us to regulate the industry. So that was a 12-month project, a 12-month journey. And there were a few other things going on at that same time. Learning the language of risk and harm so that we understood what we were talking about. So it was an important tool. The journey of developing the regulatory approach statement was an important tool for us to engage with both industry but also with the broader organisation. So it was published in 2014. What it has done is hold the course for us over the last 4 or 5 years, and it has led to the development of operational tools. So we have developed things like risk-based decision-making frameworks for our liquor licensing determinations that have policies and procedures for staff, so that when an application comes in where there are aspects that are more complex or higher risk that needs further scrutiny, that they're provided with guidance around what they need to look at, what they need to ask for, or to escalate that to somebody higher or who deals with more complex applications in the organisation. That's one example. What it actually generated for us is ideas coming from the grassroots. So we had, for example, a team leader in licensing who looked at our online portal that was used for our highest volume of applications called temporary applications. So I want to host a party in a local hall, I need to apply for a liquor licence. When we analysed those licence applications, many of them were low risk and many of them took a lot of time for our licensing officers to process. And so we established a cross-organisation project team and redeveloped the online portal, put in some administrative controls, so we were able to identify the characteristics of low-risk applications, and therefore those applications could be applied online. If they met the criteria, they would be granted a licence within 6 to 12 hours. We're able to audit those licences that we determined to make sure that it's still meeting the requirements of what we consider to be low risk. We send copies of those licences as they come through to the local council and Victoria Police, so they know what's happening in their local area. And then we use that data in our compliance area, so that doesn't mean that we may not go and inspect, but we might go and talk to local council about whether they've had any issues, talk to Victoria Police about whether they've had any issues. So the regulatory approach framework has really generated ideas and ways for us to be risk-based in our operational approaches. There are a few examples of what we've done. We've got lots of streams of work in place, and it's never ending. And I think what we have now is richer data at our fingertips to analyse whether the way we're making our decisions and the interventions that we're focusing on are leading to the outcomes that we're looking for.
Thanks. I might jump to Slido and do a couple of these. So with 16 votes, how do we say no when addressing a complaint or problem not aligned to our regulatory approach? Should we say no? So presumably this is about complainants, people wanting us to take action when it's not aligned to our regulatory approach. Can you say no to the community?
So I might start on that one. I think we have a recent compliance and enforcement policy that empowers us to say no. It empowers us to take a risk-based approach to that. What I do think though is about not using that for evil, not using it for kind of a reason that we don't want to do that, to make sure that we're making good decisions that stand the test of time, and that we explain to people why we don't do that. And the earlier we can have that conversation and assessment, I suspect is going to make it much easier in managing those cases. So we've got a policy framework that we have more than we can do, particularly at this phase of where we are in the building regulatory cycle. I think it's about making sure that we have the processes that support that, so it stands the test of time as being good decision making rather than biased decision making about what we're kind of interested in doing and not doing. And I think, like anything, that again has its place. So if you don't take a risk-based approach and you just make a decision to put one kind of cohort of people to the side all the time, then you'll get that political pressure. Like you get the reward for what you do. So if you manage those decisions well and they stand scrutiny of independent bodies and political pressure, we'll be allowed to continue to do that. If we take advantage of that, because we feel that they are squeaky wheel consumers, we'll lose that ability to make those decisions. So it's about how you do it and how you do it consistently that withstands scrutiny, and you put yourself in the shoes of the consumer or whoever the complainant is, that it's reasonable, it's in that reasonable corridor. So yes, we're empowered to do it. Would we be doing it consistently across the organisation at the moment? I would doubt so. I would think we've got more work to do to understand what that looks like. And a lot of today is about deep thinking, turning your mind to things, looking at how you solve that problem. And I would say we're a bit patchy on that across teams.
Other comments? Is this the very definition of risk-based regulation, saying no?
Absolutely, Matt. I think otherwise you're completely responsive to whatever comes in the door and people's level of willingness to make those complaints. There's no point having a strategy or a compliance and enforcement policy if you're going to say yes to the squeakiest wheel. I mean, I heard a saying the other day about, strategies being just as powerful for what you say no to as what they kind of push you towards. And I think that's what a risk-based compliance and enforcement policy allows you to do. Because the question, and it's much easier for me to say, although we get complainants in my business as well, it's really hard to say no to somebody that is genuinely aggrieved and has tried all of those avenues to get relief, and comes to you because they think that you can help. But ultimately that comes at the expense of something else. So unless it's an endless bucket of resources that you've got, and none of us have that, that's where for me the risk-based methodology allows you to go, I'm actually saying no to you because I have to do this, which is as hard as it is to hear, much more significant and serious to the community.
Everyone got that? You can say no, it's okay. Owen, I'm going to throw this one to you, mostly just so we can preserve and not sacrifice our CEO. Some of the VBA's regulatory role is outsourced to private building surveyors. Is it time to bring this responsibility back in, given widespread evidence of failure?
Well, thanks for that question.
Yeah.
Look, let's start with the reality. I mean, certainly the private building surveying industry and private building surveyors, certifiers in New South Wales, are a very important part of the industry, period, and they're a very important part of the regulatory system. So, and they're here to stay. I cannot imagine the world changing to the extent that we bring back that function back into, well, the VBA in our case, but back into government. There is, of course, one force that might head in that direction, and that is capacity to obtain affordable professional indemnity insurance, and that's a challenge that the industry now faces big time, particularly following the recent VCAT case that said, pay up, guys. So that is a serious challenge. But that said, I mean, if you were designing the system from scratch, so no one had ever built a building before today, and we were looking at doing it from scratch, yeah, you might do things very differently. But we are a heavily contracted out society for a whole range of services, and for an enormous amount of a building project, that's an entirely appropriate way to get advice on how to proceed with construction, whether it's compliant, etc. But there are, using Malcolm's lead, there are particular types of risks where we need to share that regulatory burden possibly a little bit wider, and that might mean us taking some risks rather than taking over the entire section, the role of, say, private building surveyors. We might be doing more in particular areas of risk, whether that's co-regulatory or whether it's taking over the function. I hope not, but it might come to that. We may well need to embrace that as an issue. But yes, it's got enormous implications, and we do need to deal with a whole range of issues currently associated with, well, as you know, fire safety engineering, with building surveying in general, particularly in complex commercial construction. But the idea that would result in us bringing that back into government with all of the knowledge constraints that we've got, I actually think that is very unlikely.
Very diplomatic. Well done. You'll survive another day. I reckon that one came from a municipal building surveyor, perhaps. Look, I'm just going to slightly change this question to be more inclusive. I mean, everyone sitting up here on the panel has had their own experience with Professor Sparrow in terms of methodology, etc. How do we utilise that learning, which is now a global learning? Professor Sparrow has taught to tens of thousands of students, thousands of organisations around the world. How do you keep that momentum going in terms of utilising that knowledge? Sue, what are we going to do with it? What are we going to do with it?
Look, it's like today. I mean, look, how awesome is this in terms of you've all taken time out of your really busy schedules to come and open your minds to learn, to listen, and hopefully take the conversation back to your teams, and back to your workplaces, and back to all the work that we're going to do and those that we interact with. So I think it's engaging and having the commitment to take the time to have the conversation, to learn and leverage the insight, and then to apply it and be courageous enough to really step back and think about, some of this amazing insight that we've had from Professor Sparrow and what resonates with you and how do you take that forward. I mean, the word craftsmanship today is absolutely resonated with me. I grew up on a farm. We learnt the craft of farming was all about the tool, whether it was the engine of the truck or it was the hay bale or whatever it was. And that problem solving is built into you by nature of you don't have access to specialists. And so for me today, that's been incredibly powerful. That's a language that resonates with me. And I think will live on for a really long time. So how do we, I think it's up to each one of us to stand up and take that opportunity about what resonates for us, to respect other people's views and perspectives, and to take the time to look at things deeply. That's probably another thing today is just, making sure we're unpacking these problems. When we hear this matter about the building surveyors, coming into government, well, I don't think that's the right question. From my perspective, which is what's the problem? What's the problem we're trying to solve? Because at that level, that's all too many problems probably in one. So, it's engagement. It's about respect for the different perspectives and investment, in what we do. And I think the community is looking to us for it, looking to all of us. And I think, that's it for me. Keep having these people come out and stimulate our thinking and have the courage to do something with it.
I agree. I mean, and so my first comment in coming into this forum was to commend really the VBA of bringing in practitioners and stakeholders and really opening it up beyond people who are within the VBA and your regulators. I mean, that's part of having that conversation and broadening it. My own experience as well as expectation of regulators is you do open yourself up to scrutiny, and that means being really articulate about how you target and why, and how you take action and why, and expect that you'll be challenged on that. And that, as Sue says quite rightly, I expect that if I make a decision, I can explain to people why I've made that decision. And I did it on prosecuting people and not prosecuting people, and how many fines we issued and how big they were or whatever. And I think that's just part of the regulatory craft, is being open to that level of accountability and setting a culture where you'll back people when they make those tough calls, but also when they get it wrong, that you're kind of big enough to admit that you've got it wrong and that you'll revisit it, and you can do that in a range of different ways, internal, external review, and all the rest of it. Another thing that I found, and I think, again, this comes down to the practitioner community, and I think it's Richard Johnson talks about this as third-party governance, which is that there's a whole industry out there of compliance advisors that will never set foot in the VBA, other than perhaps for a briefing. They don't want to work for you, they haven't worked for you, they can make plenty of money outside, and they're in PwC and KPMG and wherever else they work. They are actually part of your tools as well. So if they know where you target, and lawyers do a great job of this, of actually sending that message out, because it's in their commercial interest to tell people how you target and how you regulate, and how you make decisions, and then to talk about the case studies. And that's actually doing part of your work at setting that deterrent. And so using Professor Sparrow's work about risk-based regulation, about responsive regulation, and the fact that you'll get, further up a sort of hierarchy as people offend more, I think is actually part of your arsenal, that other people are telling that story.
Just a little tip, if you get yourself in trouble, just say, Sparrow made me do it.
Yeah. May I speak? I think it's important to have reasonable expectations as to what happens after a 1 or 2 or even a 3-day workshop. Normally, there are all kinds of development processes already in place, and the debates have been rumbling for a good long time. Normally, there's at least 20 different ideas of what it means to be a risk-based regulator, and therefore conversations are awfully confusing. I have frequently the delightful experience where after even a whole week's course, people will come to me and say, "Oh, Professor, you taught me nothing." which is always good to hear. We were doing it all already. But they often then say, but we didn't know what it was called. And we didn't realize that everyone was doing it. And that we are part of this bigger, broader community working in this direction or that other direction. And often from these, basic exposure to the vocabulary and concepts, my modest expectations are that you now have a common vocabulary. And if somebody says, are we or are we not risk-based regulators, at least you know to say, well, which version are you talking about? Because there's so many. Are you talking legal versus expert? Are you talking about a problem center capability? Are you saying that we know how to recognize wicked problems? What are you telling me? So it speeds up your internal conversations. It ought not to change the direction of them in a hurry. And I give you a range of concepts that you can, like frameworks, you can drop down on your organization. Some of them will reveal something interesting and useful and challenging, and some of them won't. And I don't know which ones, which is why I give you a whole bunch. And then you can do that between you. But what I do hope it does is it accelerates your internal debates, makes them more efficient through shared vocabulary, and that maybe over time, through continuing conversation, different convictions will emerge. But there's a lot more conversation between here and there. It's not like I recommended anything. I'm quite careful not to do that.
Can I add something?
Of course.
In a changing world, and there's no doubt we're in a changing world, in lots of relevant ways, we all need to act on the basis that we individually and we as an organisation need to learn and adapt and change. So what do we do with Professor Sparrow's address today and what we've learnt today? We listen, we learn, we reflect, we make decisions, and we've got to be accountable. And if we keep on doing that individually and collectively, we will adapt to the various challenges that have been thrown at us, and we'll move on as an organisation. We'll actually make progress. But if what we do is the motivation is completely understandable, we have a lovely time, so that was really interesting, and then we go back to our in-tray and we just deal with yesterday's problems exactly we do deal with today's problems and tomorrow's problems exactly the way we dealt with them yesterday, even when we've gone, oh, hang on, that doesn't sound quite right now, then we've got a problem. So we've just got to learn, and yeah, look, it'll be different for each one of us, but collectively, from a board point of view, this is very relevant to where we go strategically, and it's very relevant to the way in which the management team helps the organisation to be more effective in a regulatory space. And for my part, Malcolm, thank you very much. It's been a lot that we've learned a lot, and there's a lot to apply, and I think it's just our responsibility to get on with it.
Any others from the floor?
How could we, because statistically you can't report or can't count the accident you didn't have or the disaster that didn't occur because of good regulatory practices, how can we celebrate those things that didn't happen and didn't go wrong?
Well, that's a whole half a day normally in the course on performance measurement. For the workshop people, we'll be spending tomorrow morning on the definition of success in a risk control environment and why it's peculiar and different and challenging, and how you count things that didn't happen and take credit for them is a very complicated matter. It's not impossible. Often, if a problem was out of control, we use reductions from a high level as a proxy for prevention. It's not actually the same thing, but it is a proxy for a particular phase. And when you've eventually driven the risk down to low enough levels that there's no more reductions left, your best account is how you are skillful at spotting emerging problems early and suppressing them before they do much harm. So you can still describe that operation, and people will get to understand that it's the ability to be vigilant and nimble and skillful and squash things early before they kill many people that is what is holding the aggregate death or injury or fire rate down. And then you've got lots of engineers in the room, I imagine. Yes? No? The engineering approach to catastrophic risk control, you're working in the domain of precursors and precursors to precursors, and you can actually monitor frequency with which near misses and 3 factors out of 5 arise, and then drive those numbers down and work your way backwards through the precursor realm with more and more safety systems in reserve and the probability of a catastrophe lower and lower. That's the nature of the story. It's intellectually complicated, much more complicated than measuring reactive success, but it's not impossible.
And the Opal Tower demonstrates just how close to those thresholds you can get in Australian building law.
Systematic exploitation of your nemesis. And I have a new regulatory blessing. May your scandals be moderate and useful.
So on that topic of scandals, I mean, it used to be said that you get a crisis every 10 years, but they seem to just be coming thicker and faster all the time. And one of the questions put up by the audience is, how do you stay true to your regulatory approach and who you are, given that there's always a crisis? And we've had our fair share.
What can we say? It's accountability for the result. I agree with Professor Sparrow. It's really saying we are the regulator. We're responsible for regulating this subject matter, whatever that is, particularly where it relates to safety, and saying I will be accountable for that outcome, and that over time we are better than we were previously. And if you're not, then you should either get out of the way or kind of really rethink what you're doing. And I think the inevitable nature of it is when things go wrong, people come looking for someone to hold to account. It's really, the regulator is kind of the obvious one because it's harder to apportion blame for particularly systemic failure or those sort of high consequence, low probability events that I was talking about.
Yeah.
So you've got to be prepared to be held to account and to explain your decision making and what you've done to prevent things.
I mentioned the 4 types of work that all go on at the same time, and crisis management is one of them. And from the internal perspective, of course, when it happens, it's all hands on deck, and a lot of other routine work has to get temporarily shelved or delayed, and then it has to be restored in an orderly fashion. From the public's perspective, what they want from regulators is quite specific, depending on what kind of work you're doing. And I think what we've learned from a whole variety of reviews of crises and crisis response is the community, first of all, wants absolute honesty from government about what you know and what you don't know and how you're going to find out and when you might know. Second, they have no tolerance at all for turf consciousness or lack of coordination. There is no other time like a crisis when they want to see joined up government working intelligently as a coherent whole. And the third thing, they also want to know what they should do. They want clear instruction what to do. Apparently, during 9/11, when it was all happening, and Mayor Giuliani got on the radio and said to the public, get yourselves south of 15th Street. That this was the most incredible relief for the public not knowing which way to walk or why or what, and he at least gave them a direction. Should you, if you think there's a poison cloud coming or the possibility of a missile attack, should you or should you not put plastic on your windows? Well, nobody knows. So very clear direction from government about what they should do, how they can help themselves, and what community institutions can do to contribute. That seems to be premium during such times as well.
Unfortunately, we're out of time, and I did promise Stan we would get him out of here on the dot. So Malcolm, Catherine, Stan, Sue and Owen, thank you very much for your time. Thank you. And I think we've lost our MC by the look of it. Oh.
I snuck around the back. That's all right. Thank you, Matt. Well done. Thank you, panel. That brings, well, actually, I'd like to extend a huge thanks on behalf of the VBA to Professor Malcolm Sparrow. So one more time, give it up for Malcolm Sparrow, please. And of course, all our panellists. That brings our formalities to a close. Keep an eye on your inbox as we'll be sending out a post-event survey for your feedback. Also, if you're attending Day 2 or Day 3 workshops, please note these will take place at Meeting Room 110 on Level 1 of the Melbourne Convention Centre. You're not in the Melbourne Convention Centre, you're in the Exhibition Centre now. Convention Centre's at the other end, which is at the opposite end of where we are now. Okay, thank you and have a great night. Cheers.